This case is probably one of the more technical cases that I've dealt with in these case notes. It started with a series of warrants granted by a stipendiary magistrate in Victoria, allowing federal police to conduct searches on several premises, including Coward's premises, as part of their investigation into money laundering offences. A number of those who were subject to the searches challenged the validity of the warrants. The challenges were all based on Section 75(5) of the Constitution, which says that the High Court, and by extension other federal courts, have original jurisdiction in any matter in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth. The parties challenging the decisions had two lines of attack. One was to seek an order for certiorari to bring the warrant decision before the court, and then prohibition, prohibiting the magistrate from issuing the warrants. However, the magistrate was not an officer of the Commonwealth. They were a state appointee, even though they were exercising Commonwealth jurisdiction. So they didn't come under Section 75(5). The second line of attack was to seek prohibition and an injunction preventing the federal police from actually carrying out the searches. This they could do, because the federal police are officers of the Commonwealth. Now, in the end, for reasons that we don't need to go into, they failed to have the search warrants set aside. For our purposes, though, the important factor to emerge from this case is that even in the age of the Administrative Decisions Judicial Review Act, the ADJR Act, it remains entirely proper to seek the constitutional writs of prohibition or injunction against a Commonwealth officer. Justice Northrop said, "Each federal police officer is an officer of the Commonwealth. Each is claiming to be entitled to retain the things seized under the authority of the warrants. In executing each of those warrants, the officer concerned had an implied authority to search and to decide which of the things mentioned in the warrant should be seized and retained. The power to make decisions of that kind is, in my opinion, sufficient to make those officers subject to the prerogative writ of prohibition." So from this case, we confirm that the constitutional writs, which arise directly under the Constitution, remain in place, even though parties now may also seek redress under the ADJR Act.